talk about. So talk about what you want, what you chose.
Sure. So I thought we would bring up a case that has to do with estate planning, because really estate planning, wills and trusts, those are not typically federal jurisdictional cases. They don't go to the Supreme Court. It's hard to find cases that do get there that relate to my practice area. So I found one as recent as 1875. And this case I wanted to tell you about, it's about spendthrift clauses. So what does that mean, right? Spendthrift clauses are a provision in trusts. We use them all the time these days. They're really common. They protect an interest in a trust. But what's interesting is that spendthrift clauses, the legitimacy of them, that came to be as a result of the Supreme Court case in 1875.
You and I had a chance to talk a little bit about that, and I'm always amazed at where these things come from,
right, because sometimes you don't know why you do what you do.
Exactly.
Or why do we say what we say?
And there's always some reason, but and when you get into law, you just kind of, this is the way we do it. Well, why do we do it? Well, that's just the way we do it.
Right. And in this case, we had a widow, and she had created a testamentary trust. It's a trust and a will. And she wanted to leave her estate to her kids, but she didn't want her kids' creditors to be able to touch it. And at that time, it was highly controversial whether creditors could get this trust interest. And, we don't have a lot of time to get into the details, but basically, as a result of this case, people were given the right to protect that interest from the creditors of the beneficiary.
Okay, so now I'm interested. What's the name of the case?
Nichols v. Eaton.
And from 1875. 1875.
Nichols v. Eaton.
Now, again, as you mentioned, that is a huge part of estate planning nowadays, right?
Right.
You're going to give somebody money. You want to make sure nobody can take it away from them.
Right.
Their own creditors.
And, logic would follow that if your beneficiary has creditors, they potentially could reach this inheritance. But this spendthrift provision is a protection that we can write into a trust. And the validation of this is based on a Supreme Court case. I mean, that's the Supreme Court working to protect the interests and validating provisions to do so.
Talk about what I think about when the case stays with us, right? Precedent. Talk about precedent, right? I think it goes back, and it's like, it works, right?
Right. Well, 1875 is, not yesterday.
It is not yesterday.
So it's still good law.
That's amazing. That's a very good case. And again, I think that when the attorneys get involved, we kind of just do especially now with computers, where we just kind of everything's kind of written, and you kind of template.
Well, I'm glad you brought that up, because to tell you the truth, I think that, not that I would not tell you the truth, but frankly speaking, especially on the Trust Radio Network. But what I mean to say is, frankly speaking, I think a lot of attorneys out there will do some kind of estate planning, but there's a difference between an attorney who does some estate planning or claims that they do and an attorney who is an estate planner, because templates are available, but templates are just like your just like your cookie cutter house as opposed to your custom house build.
Mm-hmm.
There's a big difference in what you're going to get. And I'm not sure that everybody realizes that. So an attorney that concentrates in estate planning is probably a little different.
And I have to say, in my own practice, when I was younger, I did some basic, nothing really, I did a will for somebody or something. I had some friends, and I also did a lot of real estate in my time. But now when people come to see me, I don't do any of that. I just, that's not what I do. You got to pick kind of what you do and stick with what you do.
It has gotten the law has gotten very complicated as time goes on.
Well, I think that's in every area, isn't it?
Yes.
Okay, so we're here.